Hey, what's up, everybody? This is attorney Dan Nguyen again. And today I want to talk to you about trademarks and what do you do if your trademark was rejected because it was descriptive. Now, a lot of people that file trademarks on their own run to this particular issue because the trademark office looks at trademarks partially on a spectrum, right? There are weak trademarks and there are strong trademarks. And on kind of the weaker side is what's known as descriptive trademarks. Basically, you're saying what you're selling or providing in that particular mark, right? So one step above, closer to stronger, are what's called suggestive trademarks. So suggestive trademarks are like Microsoft, right? So you don't really know what they're selling based on the name. Even stronger trademarks are arbitrary. So arbitrary marks are words that exist in real life, but don't really have any connection to what they're selling. So things like, Apple for computers, Apple for music, right? Apple, as we all know, is a fruit, but it took them a very long time for to get the public to associate them with all these, electronics and music and things like that. Now, even better than that are words that are made up. So these words that really exist in real life, like Xerox, right? And so these are afforded protections in the trademark office. Now, you still have the issue of like similar, confusing, and there's another company, but those are kind of one hassle that, if you can get over that, then you don't have to deal with that. But back to, descriptiveness, right? What if you already picked the name, you've been using it for several years now, right? And you go ahead and try to do the trademark, but the trademark office sends you an office action saying, hey, we're going to, there's an issue here. And one of the issues is that it's merely descriptive, really just describing or just sharing with us what you guys are selling, right? So one, you can make the argument, right? So depends on the word and a lot of different factors. You can make a legal argument, trying to overcome that issue. Now, I do want to talk to you more about, like, okay, if it's going to be really hard to overcome that particular issue, like what are your options, right? First one is, you may have seen this in your office action, is go on the supplemental register, right? The supplemental register is like a different list where trademarks go to if they're not as strong. You don't get as much protection, but one of the kind of upsides is that when someone's searching for the name, that name, your name, if it's even on the supplemental, that'll pop up, right? And that might deter some people from trying to get the same or similar name. So I would say, like, hey, the supplement is better than nothing. You always want to be on the principal register, which is kind of like the big brother list. But if you can't get there, supplemental is better than nothing. And you're already there, right? You're halfway, 3/4 of the way through the application process. Go ahead and make that switch to the supplemental register. Now, one caveat also is that you do have to be using the mark in commerce. You have to be selling underneath the name. So, like the principal register, right? You have the option of an intent to use. If you're not using it, but have a bona fide intent to use the name, you can put an application in, right? So even if you're not using the name yet, but for the supplemental register, can't do that. So if you initially start with a 1B application, intent to use, and you're getting a rejection for merely descriptive, you can't go to supplemental unless you are actually in business selling underneath the mark. Now, there's another one that you might be able to use. It's called the 2F claim, which basically says that, hey, I'm making a claim that I've been using this name, this mark, long enough that has built some strength. It's called built distinctiveness, right? So you might have to show some evidence, like, hey, your sales over a certain amount of period, how many maybe new Instagram followers do you have, things like this. You do have to prove that your brand has become stronger over time. That may get you on the principal let you stay on the principal register. Now, one of the issues of picking this is that now you are kind of making like you're basically admitting that, hey, this is a descriptive trademark, and and it's taken me a long time to build up. So it might be a wrinkle if like in the event that you have to defend your trademark. They might be able to use that against you. Say, hey, they made a 2F claim, and 2F claims are basically saying, hey, these are merely descriptive names that shouldn't get afforded protection. So there's kind of a balancing thing here, but that is a particular option that you can do. One other one also is if you have both the kind of the word mark and you're doing a logo. And depending on how the logo is, and what I mean by logo, it has some sort of artistic element plus the name. You might want to consider doing the logo mark application as well, and then you might have to disclaim the words, right? So we've already discussed, hey, the words that you're using on the as a mark is like merely descriptive, that's not allowed to get a not allowed to get protection. But as the applicant, I want to get protection over that kind of the artistic element that maybe it's a swirl, it's a triangle, whatever it may be, right? So you're making claim to the artistic part or artistic part of the application. So that is kind of one strategy that we've suggested to our clients that depending on their resources, depending on their position, depending on where they are, that they can do. So hey, my name is Dan. Just want to talk to you a few options about if your trademark is, getting rejected because it's merely descriptive. A couple options that you might want to think about in moving your application forward. All right, this is Dan, and I'll talk to you soon.